I think I'm going to start because we haven't had another participant for a little bit. So my name is Jenny Jones. I'm a member of the House of Lords for the Green Party, which sounds quite elite, but I can assure you it's very, very hard work. I've had a long-standing interest in justice and road danger reduction, probably from about 2000. And it's been a tough haul. I was previously under Ken Livingstone as a road safety ambassador in London, which was great. He sent me out on all sorts of things. And I was former chair of the All-Party Parliamentary Group for Justice for Road Crash Victims. And I'm also president of the Road Danger Reduction Forum. And it's very good to be here this evening. And thank you all for coming. It's quite rare to be able to discuss sentencing without different perspectives. And so here we have that opportunity. So we're going to talk about sentencing to reduce road danger and to help promote active travel. So if you can remember that this evening is about sentencing, not charging standards or downgrading, but the decisions after conviction. And we will also be talking about causing death and serious injury by careless driving. And the focus is on the offences of causing death and serious injury by careless driving. The consultation that we're going to be talking about covers 12 offences, but we want to focus particularly on what causes death or serious injury. And finally, on disqualification. The consultation is focused on custodial sentences, although it does include a section and a question on disqualification. Now, we recognise that the Sentencing Council has given more priority to disqualification, but we want more. I mean, personally, there would be a lot of disqualified drivers in the UK if I had anything to do with it. So, first, we are going to hear from Ollie, Ollie Simpson. And he is the person to ask all the difficult questions of. He's from the Sentencing Council, and he's going to give us an overview of the consultation. So, Ollie, can you go ahead, please?
Certainly, thank you very much, Chair. So the consultation that we've gone out on ran from the 7th of July to the 29th of September this year. But I should say what I've said to Amy and others, that I will still accept responses from attendees here, given that I think we were going to have something like this event during September, but it was delayed because of the mourning period. So I have granted a few extensions to people. It went on over the summer, and then there was the mourning period, etc. So it's fine to, if people still want to use this week or even next to get responses in, I'll understand. If you could go to the first slide, please. Thank you. We consulted, as Baroness Jones said, on 12 guidelines. Some were revised versions of older ones, which had been published in 2008, and some were completely new. Now, an important thing to bear in mind is that we've been planning to update these guidelines for at least 6 years, I think, well into the last decade. We have waited really on the government to introduce their increase to the maximum penalties for causing death by dangerous driving, causing death by careless driving under the influence, and the new offence of causing serious injury by careless driving. So those became law this year, and so we launched our consultation. So over that time, the last few years, we've had feedback from victims and their families about the need to update the guidelines. We've had magistrates calling for better guidance on drug driving, and we've had correspondence from MPs. We've kept in periodic contact with DFT, as you'd imagine, and indeed with Professor Wolf at King's College about the scientific evidence on drug driving, so that we can develop guidelines there. And the consultation went out directly to a wide range of groups, as well as the usual criminal justice groups. We went out to Break, Safety GB, the Royal Society for the Prevention of Accidents, the Road Safety Foundation, and many others. And I'm pleased that we've had responses from many of these groups, as well as actually a large number of individuals who've been affected by motoring offences. Of course, victims themselves and their families, and vulnerable road users like cyclists. But we've had some responses, I think, from offenders themselves, so getting their perspective is very useful.
Ollie, I'm so sorry. Can I stop you? I'm a terrible chair. Could everybody please mute themselves? Syed, Imran, Ahmed Shah, we can hear something from you. So could you please mute yourselves? It's quite distracting and well, that's perhaps it. Ollie, so sorry to stop you.
Not at all. I hope that's a little better. Yes, so during the consultation, we've done a lot of work with magistrates and judges in the Crown Court, with magistrates and with judges in the Crown Court on road testing the guidelines to make sure that they work out broadly as we intended, and to see if we can fix any bugs with them. The drafts that we've consulted on do take some elements from the existing 2008 guidelines. We've obviously used recent transcripts from the Crown Court as well. We've looked at current statistics on sentencing levels, although bear in mind, of course, that with the maximum penalties being brought in by the PCSE Act, we've had to balance the existing sentences with the will of Parliament in increasing that in some offences. So turning to the guidelines, the next slide, please, Vicky. Thanks. Obviously, I'm not going to go through each one that we're consulting on, but I'm going to focus primarily on the careless driving offences, as that I think is what we're mainly interested in here. So the existing causing death by careless driving guideline dates from 2008, and the format is very much out of date now. It has a 3-level culpability table. That's nothing unusual. As you can see there, the lowest category is momentary inattention. The highest category is something just short of dangerous driving, and then we have a catch-all middle category of anything in between. But what I haven't shown in the slide is a huge block of text, an essay length really, explaining some of the key determinants and factors relating to seriousness which apply across this guideline and a range of the motoring guidelines. And that's not really the way sentencing guidelines operate now. There isn't a huge amount just sort of discussing the seriousness. You've got your culpability table, and that's what you apply. Now, one of the elements that was discussed in that big block of text was the victim being a vulnerable road user. That's where it was mentioned. Whereas what we've done in our new proposed guideline is make that an aggravating factor, and I know some of you will want to talk about that. The reason why we did that was, I mean, first of all, it's a symptom, if you like, of changing the format of the guidelines so that really the culpability factors in the new guideline really relate to the offender's standard of driving, which is a separate matter to the victim being vulnerable. That said, there is some crossover because we have factors like unsafe manoeuvre or positioning, and those might well relate to whether the victim was vulnerable, and things like the road conditions could be taken into account at step 1 as well. So let's take a look at the proposed culpability factors for careless driving. In the next slide, please, Vicky. Thanks. It's slightly small text, but structurally, these are sort of similar to the old guideline. The bottom level is for those momentary lapses. The top level is for something which is just short of dangerous driving. And the middle category is a catch-all again, but we've provided more detail on the sorts of things that you might see in this category. That's unsafe manoeuvre or positioning, I mentioned, engaging in a brief but avoidable distraction, driving at a speed inappropriate for the prevailing road or weather conditions, and then a variety of things, driving whilst you're impaired as a result of alcohol or drugs, where visibility is obstructed, where you're on medication, when you're tired. So more or less, the culpability levels between the old and new guidelines are comparable, which means we can make a meaningful comparison of the sentencing levels. So on the next slide, Vicky, thanks. So the old sentencing levels were, or still are technically, for a very high culpability offence, 15 months custody is the starting point. For medium, it's 36 weeks, and at the lower level of culpability, it's a medium level community order. And then the second range is what we're proposing here. The second table is Oh, sorry. For high culpability is a starting point of 2 years custody, a medium starting point of 1 year's custody, and then the lesser culpability of 26 weeks custody. So things have been inflated a little bit there. They've increased. There are limits on what we can do here. Obviously, primarily we're constrained by the statutory maximum Parliament has set, and it's worth bearing in mind that the new maximum penalty of life for causing death by dangerous driving gives you a big chasm between causing death by careless and causing death by dangerous. And equally, we also want to ensure proportionality with the new offence of causing serious injury by careless driving. So I'll sort of introduce that guideline now with the next slide. This is one where there isn't a current guideline to draw on. There aren't existing cases, there aren't existing statistics. But the culpability factors will be the same because it's careless driving. As the ones we've just looked at. The sentencing levels we propose, I won't go through all of these because we could be here, but high harm, high culpability, the sort of top box will be a starting point of 1 year, 6 months with a range of 1 to 2 years, and that's the maximum penalty set by Parliament. The middle box there of lesser harm and medium culpability has a starting point. Sorry, the middle boxes have a starting point of 1 year's custody, 26 weeks to 1 year, 6 months custody at the top. And then the lowest box there has a starting point of a high level community order with a range of low level community orders to 26 weeks. So most of these starting points are custody, but there is a community starting point in the lowest box there. You know, again, to re-emphasize the point, there's not a huge amount of room for logical manoeuvre here. We need this to follow on, as it were, from the table for causing serious injury by dangerous driving, and where higher culpability needs to be reflected in higher sentences where the same harm is caused. Note something important about these sentences, where they come in the sentencing guidelines. This is before aggravation and mitigation. Really crucially, it's before the application of a reduction for guilty plea, which I should imagine there are plenty of in careless driving cases. Something to bear in mind as well is that all the custodial sentences in this range are suspendable. And that's something which is going to be very fact sensitive towards the offender. And so I would anticipate that a huge proportion of these probably would result in suspended sentences. I know a lot of people want to talk about disqualification, so if we can move on to the next slide. We did provide we are proposing a new section on disqualification that comes at step 6 of the guidelines in relation to ancillary orders. It is general guidance on topics that we know some sentences can struggle with, and in particular the rules around factoring in custodial sentences. So we set out the principles first. It's important to remember this is a punishment. It's also something which is a crucial part of the sentence and needs to follow the purposes of sentencing. Important to bear in mind the need for rehabilitation and the fact that some people may need to get jobs or do volunteering work when they either leave custody or at the end of their sentence. There's also the risk that we encounter in practice that lengthy bans, the sort of life bans that people would call for sometimes, may just tempt someone back on the road because they've got nothing to lose. And that's been reflected in case law over the years. We provide details about minimum disqualification periods, including repeat offences where it's appropriate, and there are some circumstances where those might be avoided in relation to the offence. And then that information about the interaction with a custodial period, both where custody is imposed for this driving offence and where it might be imposed for another offence. Calculating exactly how much to extend for a discretionary ban for to take account of custody can be tricky for sentences, particularly where you have multiple prison sentences that you're having to take into account that may be concurrent or maybe consecutive. So a big question is, could we have given specific periods for disqualification? Well, we could in theory, and we did think about doing that very carefully. We concluded it would get difficult though, Disqualification is something that's very specific to the offender and to the offence, because it relates, for example, to how much they recognise what they've done, whether they are viewed to be a sort of forward-looking danger to the public or not, and so we could, I suppose, in theory, have given a very wide range, but we felt that would be virtually useless, because people would just be left shrugging their shoulders anyway. Also bear in mind, for the new very high minimum periods for death by dangerous driving and death by careless under the influence, so that's at 5 years minimum, it's difficult to provide realistic and meaningful ranges once you've imposed a lengthy custodial sentence, as might well be the case with those offences. You're then looking at applying 5 years beyond the release of custody, and some of the periods that you talk about would start to be quite unrealistic. And there's an interesting interaction in practice with what other punishment is being imposed, and you see this in some cases. If a community order or suspended sentence is being imposed, then actually that's where lengthier disqualifications really come to the fore and become a key part of the punishment. Whereas if someone's going to prison anyway for a very long time, then it may be the case that, relative to the other cases, a shorter period of disqualification after release might be considered sufficient for public protection and by means of a deterrent for the individual. So in road testing, most of the sentences thought that this guidance was fairly helpful. I mean, not universally acclaimed, but most said that they didn't necessarily want to see periods in there. That could be the case. That could be because we were deliberately testing borderline cases, and for most of the time, the statutory minimum was the one that they thought was most appropriate. Amy, I don't know. I've asked. You asked a specific question about tags and whether that was something that the council could mandate. So electronic tagging is available for community orders and suspended sentence orders. So in theory, a guideline could say that it might be appropriate in certain cases. I wasn't totally sure whether if someone had managed to avoid disqualification or wasn't in prison, what a tag might do. It can sort of put limits on people's movements, and you can enforce sort of curfews that way, I suppose. But of course, it's going to give you limited information. So if someone catches the train somewhere or gets someone else to drive them, then I don't know that you'd be able to tell whether they were driving or whether there was another idea behind the tag. So we don't generally talk in much detail about what disposals might be imposed as part of a community order, because sometimes there'll be issues with availability. But I'd be happy to talk a bit more about that as we go through the meeting. So we've received over 300 responses, and that's a great response from everyone. We're really pleased to have got that. Given the scale of the consultation and the number of responses, it's difficult to give a cast iron guarantee of when we'll publish a response with the definitive guidelines. I hope it will be spring next year, so that the guidelines can come into force around summer, but that will be subject to council discussions now. And then in terms of monitoring how they're used, as with all guidelines, around 2 or 3 years after they come into force, we'll gather data to see what, if any, changes to sentencing practices have occurred as a result of them, and then we'll decide whether changes need to be made then or whether we can look to revise them in the future. So I hope that's been a useful tour through what we've consulted on, and I don't know if you want to take questions now, or I can take them as we go along. That would be fine.
Ollie, thank you so much. That's excellent. We'll take questions later. We're going to have two chances to ask questions, but first we're going to hear from a few of the other speakers. And first we'll hear from Amy, who is from Action Vision Zero, and she's going to give some context to this whole thing. So over to you, Amy.
Hi, thanks, Jenny. I just wanted to put tonight's event into perspective for everyone. It's being organized by Action Vision Zero. We're a small company interested, community interest company, basically a campaign promoting road danger reduction. We've been working on a roads policing campaign for the past few years, and that has included calling for tougher penalties, especially with a focus around driving bans. We've highlighted how rare they are to be used with speeding and careless drivers. And I want to say, like mini campaigns, our work is mainly volunteer led, but we do have a small grant from Foundation for Integrated Transport, and that's from the Alistair Hanton Memorial Fund. And many of you will have met and had the honor of knowing Alistair. He was a leading light in reducing road danger, whether it was with the Slower Speeds Initiative decades ago or with Action on Lorry Danger. He really was a force for good, and I know he'd be proud of this event, because we're trying to identify what's both constructive and fair tonight. I wanted to say that we hold a monthly meeting with the local roads policing campaigners, and we are grateful that the Sentencing Council was going to come and talk to us about this consultation. But then when the Queen died and it got all postponed, we thought that we should definitely open it up and have a wider debate, because this is a confusing subject. And so just wanted to thank all the speakers for joining and all the participants for listening. I know the conversation will continue beyond tonight. We've been campaigning on these issues for many years. But anyway, I just wanted to say thank you for coming and give that background.
Thank you, Amy. Now, next we're going to hear from Sally Kidd, who is head of the law school at Leicester University, and she wrote the book on driving offences and is a leading academic in the country. So we're very, very lucky to have her. She's also conducted research on the prosecution of careless driving that endangered vulnerable road users. So I'm looking forward to her views. Now, I see that Andy Cox has joined us, and he is actually at a hospital at the moment. And if he's listening, we could put him in after Sally if he would like that. But if not, we'll carry on with a plan that we've devised. So Sally, looking forward to hearing from you.
Thank you very much, Jenny, and thank you to Amy for inviting me to speak this evening. I prepared these slides this afternoon, obviously not knowing what Ollie was going to say in his presentation, and I think what he has said it was a clear explanation of what's being proposed in the time available to him, I think. So there might be some overlaps, but I'll try and focus on differences in my presentation. So as Jenny said, I happen to be head of law school at the University of Leicester, but I did my PhD. Well, I did my PhD on what Jenny mentioned at the beginning, what we're not looking at today, which is the decision that prosecutors have to make between the different offences available to them when there has been a fatal road traffic collision. I did the research for that just after the turn of the century, actually. So and the cases that I was looking at were from that time, and obviously so Ollie mentioned the chasm that now exists between causing death by careless driving on the one hand with a maximum of 5 years imprisonment, and causing death by dangerous driving with a maximum of life. That is a big gap, but it's still smaller than it was when I did my research, and the difference was 14 years for causing death by dangerous and just points on your license if you committed careless driving, because there was no causing death by careless driving offence. So we have seen the law progress massively in that time, I think, and be far more punitive towards careless drivers. Next slide, please, Vicky. So I didn't know how much Ollie would be saying about this kind of thing. So just making the point that these are new proposals that follow the pattern of the approach taken by the Sentencing Council more generally to all of their guidelines now, and I think that has been a benefit to the criminal justice system as a whole, to have very structured approaches that allow for consistency in sentencing, but there are questions that come from that. So he's already said some of the difference in relation to that, and it was already the case that the existing guidelines followed the pattern of looking at what, combining the two elements of harm and culpability. And when we're looking at the causing death offences, obviously the harm is consistent there. So we're just focusing on the culpability, but with the other offences like causing serious injury, then harm becomes part of that. But as he explained, there are differences now in having that clear list of categories for high culpability, medium culpability, less culpability, and not having that big long essay, as he put it, before the tables. And I think this is a question that some people want to discuss tonight. Well, I'll come back to that actually. Then obviously you've got the aggravating and mitigating factors alongside the fact that there are certain examples of driving that fall within the different levels of culpability. What that allows for is you've got the sentencing range with a starting point, but once you've just determined which level of culpability, so most of these offences, well, I think they all have three levels of culpability, unlike some other offences. So if you compare, for example, causing death by dangerous driving with manslaughter, manslaughter has 4 levels of culpability, or harm and culpability rather. Well, yeah, no, culpability, because harm's the same. So yeah, I mean, once you've got that, you've established your culpability, whether it's A, B, or C. You've got your range there, and then it's the mitigating and aggravating factors that raise you up and down within that whole range from the starting point. So that's what we think. I think we need to think about when we decide whether something should be within, or what the influence is of a factor falling within culpability rather than aggravating or mitigating factors. And he's already explained the need for these new proposals. But there is, I think, as has been mentioned before the meeting started proper, some overlap then, or difference of approach this time round between culpability factors and aggravating factors, such as the role of victims, vulnerable victims, that now being listed under an aggravating factor rather than influencing culpability. Is that right? It does mean that it could influence the range within which a sentencer is ranging, and then it's an aggravating factor that it's a vulnerable road user. Does that mean, though, that actually, you know, it's because it's already within a range, it's not as a longer sentence as it might be had it been a culpability factor? Whether that's appropriate or not is something to discuss. I think what's difficult for the Sentencing Council is that they are not determining the definition of offences, nor how they're interpreted either by the CPS or by magistrates and juries in court cases, and they're just looking at what the sentencer is having to decide at the end of it. And I imagine you could have cases involving vulnerable road users which are very different in nature. Some may be the driving itself is dangerous because of the presence of vulnerable road users. Others where it's not actually the presence of vulnerable road users that makes the driving dangerous, it aggravates it, but it's dangerous for some other reason, or careless for some other reason. So I think that is difficult. And then there's also a potential overlap, as I say, in that last example, elements of the offence with elements that are relevant to sentencing. So, for example, bad driving, so whether it's careless driving or dangerous driving under the influence of drink or drugs, could amount to a Section 3A offence, by which I mean causing death by careless driving whilst under the influence of drink or drugs. It could provide evidence of that offence, but it might also be that the driving is bad enough that it's prosecuted as dangerous driving, where drink or drugs isn't mentioned in the label of the offence, and it then becomes an aggravating factor. Similarly, I think inappropriate speed is, we know, according to we were discussing this earlier, the TPS charging standard, speed can be evidence of dangerous driving, but also it can be a factor in showing medium culpability for the Section 1 offence, which is causing death by dangerous driving. So there are these overlaps, and it's, I think, perhaps particularly difficult for the Sentencing Council in their task to iron out, given their role in the criminal justice system, how these things should be taken into account. And I just wanted to highlight here the role that luck plays in the outcome of these cases. So this is, I think, something that has always troubled me since I started to research these offences, that whether somebody overtakes on a blind bend and luckily doesn't result in a collision because there's something coming in the opposite direction, or whether they do so and there's carnage, isn't within the control of the driver. So whether they're sentenced to a maximum of 2 years imprisonment for dangerous driving or life because they've caused somebody's death isn't within their control. What we've seen then is an increase in the maximum penalties for the worst outcome, but we haven't seen any difference to the maximum penalty for the underlying offence, in that case dangerous driving. Next slide, please. So I'm going to use this as an example to just talk about, given the limited time available to me, the proposals in relation to causing death by careless driving, which is the offence under section 2B of the Road Traffic Act. The idea here is that although the maximum penalty for this offence has not increased, it's still 5 years as previously, the fact that the maximum penalty for causing death by dangerous driving has increased to life, and therefore that offence warrants a higher sentence under the sentencing guidelines, has this knock-on effect for causing death by careless driving. And we have to remember that, as we've already discussed, whether it's the Crown prosecutor making their initial decision as to what offence to charge, whether it's the jury in a Crown Court case deciding whether the charge of causing death by dangerous driving has been proved, or whether they should convict of the lesser offence of causing death by careless driving. At the end of the day, there's a lot of overlap between these offences. The judgment of whether a driver has fallen below or far below the standard of a competent and careful driver. So I think it makes sense that we should see an uplift for the proposed sentence guidelines for causing death by careless driving. What I would take issue with is the Sentencing Council's claim that this is a modest uplift. Ollie shared earlier on his slide the differences between the existing guidelines and the proposed guidelines, and as we see, there's a lot more imprisonment involved in the proposed guidelines. So a lot more offenders will be subject to a prison sentence, whether that's suspended or not. And I wonder if I haven't looked to what when the government passed the bill that increased the maximum penalty for causing death, what the implications were in terms of the cost of that for prison places and that kind of thing. But that does mean then that overall, I think you can see that there's a difference of about a year's increase on the difference between there's an increase in the sentences for causing death by careless driving, but contrary to what I think was suggested earlier, the cases at the border represents a difference of a year's imprisonment. If you look at the highest end of causing death by careless and the lowest end of death by dangerous, there's only a year's gap in terms of those penalties, and that's actually smaller than the current gap, even though the sentence has been increased for the more serious offence. So does that suggest that the Sentencing Council has gone too far that way in trying to close the gap? I don't know. And just wanted to mention a couple of the aggravating and mitigating factors here. So just to make the point that serious injury is an aggravating factor, and some people might raise the question of, well, why is it an aggravating factor when it should be charged as a separate offence? Well, it could be that where there's been a collision and there's both death and serious injury, both those offences are charged. But if somebody is sentenced for causing serious injury by careless driving alongside causing death by careless driving, sorry, I'm mixing up my words now, it would be a concurrent sentence rather than a consecutive sentence. So it wouldn't increase the amount of time that somebody served in prison. So it makes sense that it should be an aggravating factor for sentencing the more serious of those offences to make sure that the actual penalty served is longer. And then I wanted to make the point also that I think it's appropriate that one of the mitigating circumstances listed for causing death by careless driving is the actions of the third party which may have contributed significantly to the collision. I think that's particularly the case given the case files that I've read. It's often the case, I find, that where you have a collision that is caused by a careless driver, there's at least some blame on both sides, particularly when you've got, this isn't necessarily looking at vulnerable road users, but when you've got two car drivers that are involved in a collision and somebody in one of the cars dies, it's not uncommon, I think, that there's more than one contributory factor in terms of the driving to that. So last slide, please. I won't say too much about this. I think I didn't click the start on my stop clock as I had intended to do, but I suspect my time is just about running out. Yeah, I'm not convinced by the argument that it's too complicated to have guidelines on periods of disqualification for these offences. Yes, it's very complex, and we see that by the fact that the Sentencing Council is also currently consulting on an additional consultation on how the law on disqualification should be applied. It is very complicated, but the idea that there's too many offence and offender specific factors to influence the period of disqualification, I'm not sure that I see the distinction between that and prison sentences. There's always going to be those factors in play for prison sentences as well. I do feel that probably it's more the point that the Sentencing Council is having to defer to the Court of Appeal in the case of Islam there. So I think I would like to see more than just a set of general principles in relation to periods of disqualification. So I will leave it there. Thank you, Jenny.
Sally, thank you very much. That's raised some questions as well. Next, we're going to hear from Tom Franklin. It's a video from the Magistrates Association. This is very important because causing death and serious injury by careless driving are either way offences, and many of these cases will be heard and sentenced in the magistrates' court. So it's quite important to hear the magistrates' view. So, and after that, we're going to hear from That's very interesting as well. We're going to hear next from Roger Geffen, who has been a campaigner for probably longer than I have. He is a long-time campaigner. He's head of policy at Cycling UK, and he recently coordinated a campaign to get the police crime sentencing and court bill to include more about motoring offences. That was a long bill, and it took us quite a lot of time in the House of Lords. One of the charges the consultation asks about is causing injury by wanton driving. And this can be used with cyclists accused of causing injury or death. So over to you, Roger.
Thank you, Jenny, and thank you, Amy and Vision Zero, for inviting us to speak. Yes, thanks, Vicky. If you're just getting my slides up, that's great. So that's my title. That's my title slide. I'm just going to start. Just go on to the first detailed slide. I'm going to start with a few slides, for just three, that do go beyond the remit of what we're talking about, of the specific role of the Sentencing Council, and then I will zoom in on what we can literally say. I'm doing this because I think this is evident from the previous contributions, particularly from both Ollie's and Sally's contributions. Actually, sentencing cannot exist in isolation. There are a whole wider pack of problems with the framework of road traffic law and enforcement, which I will just outline briefly to give you a picture of where we're coming from, and then zero in on what we can and what we will be saying, and indeed some of the limitations on what we can say, given the limitations of the Sentencing Council's role. So let's start with the wider picture of where we're at. Careless and dangerous driving, the offences are very unclearly defined. I will say a bit more about that in the next slide. The framework of sentencing is over-reliant on custodial sentencing, insufficiently reliant on driving bans, and the very fact that it's over-reliant on custodial sentence is probably what makes jurors so reluctant to convict for dangerous driving in the first place. That is a fundamental problem with with the legal framework. And until we fix that, then it's very difficult to fix some of the other things. And I absolutely agree with Sally in recognising some of the difficulties the Sentencing Council faces in dealing with this very flawed framework that is flawed in so many wider ways that the Sentencing Council on its own cannot fix. The fact that we're insufficiently we make insufficient reliance on driving bans, however, but that has two knock-on things. It's too easy to avoid driving bans by pleading exceptional hardship, despite what has just been said about that. There are still too many cases where drivers are pleading, well, I couldn't take my dog for a walk in the park within a mile, and getting away with exceptional hardship. That's still happening despite the latest changes to the guidance. So the exceptional hardship thing is still not working as it should. We've also got insufficient maximum sentences for driving while disqualified. If, on the one hand, if we're saying that when people drive in a way that causes danger, but they're not a dangerous person, therefore we should disqualify them rather than lock them up. However, if they breach a disqualification, then we really should be locking them up. And being able to plead exceptional hardship, or having effectively a slap wrist when you breach a disqualification and you still get just another disqualification, that is wholly unsatisfactory. That's failing to take off. Obviously, willfully drivers who are clearly willfully disregarding the law, effectively showing contempt of court by driving after being disqualified. That's got to be dealt with much more seriously. I will leave some of the many other ways in which other sentences are inadequate. Let's move on. I wanted to say a bit more about this careless dangerous distinction. It's already been mentioned that dangerous driving is defined as falling far below what would be expected of, quote, a careful and competent careful driving, and that danger should be where there would be that should be dangerous where it should be dangerous where there is obvious there is causing dangerous, where that danger would have been obvious to a careful and competent driver. And yet so many cases result in danger that should have been obvious to a careful and competent driver, and yet they still get dismissed as careless driving. We've got to replace this reliance on is the driving far below or merely below, and what is a careful and competent driver anyway? It does seem that jurors have a tendency to think, well, that's me, I could have made that mistake, I wouldn't have want this person sent to prison. And in many cases, it's quite understandable that they don't want this person sent to prison, but that doesn't mean that the driving was not dangerous. Under the current legal framework, if it's caused danger that should have been obvious to a careful and competent driver, it should be classed as dangerous. It should not necessarily follow that the driver should receive a custodial sentence. We've got to break the link here, the link. So the fact that so many offences are, the fact that the legal framework still has this word careless in it is still causing confusion. And let's move on. In particular, the obvious symptom of that lack of clarity is that 93% of drivers convicted of causing death by dangerous driving face immediate custody. That is far higher than it should be. If dangerous driving is an objective test, i.e. has it caused danger, and only sentencing can make the distinction, well, is this a driver who needs to be locked up as a result of having driven in a way that caused obviously foreseeable danger, or was it a momentary lapse of attention for which they should face a driving ban but not a custodial sentence? That's rightly where the Sentencing Council should be coming in. So 93% of drivers getting for causing death by dangerous driving getting custodial sentences is too high, and unfortunately I fear that what the Sentencing Council is doing is going to make that even harder, to say, well, actually they should get a non-custodial sentence, but it should be quite a significant driving ban. So that so many drivers get custody when convicted of a dangerous driving offence, whether it's causing death or whether it's causing serious injury, there is this apparent link that if it's dangerous, that's custody. And we've got to break that link, because if jurors think that, then they will be very reluctant to convict for dangerous if they think that could be, that shouldn't involve prison. And therefore, the distinction that should be applied between careless and dangerous is going to get even more confused. This is exactly why there needs to be a wider review of road traffic offences and penalties, something that the government promised long ago as for 2014, then again in 2021 during that campaign that Jenny just mentioned around the police and crime bill, and we're still waiting for it. So there's only so much that can be done in current circumstances, but I do want to point to what can be done and the limitations of what can be done. So let's move on to the next slide. As Sally's also said, there are limits to what the Sentencing Council can and can't do. They can't redefine, they can't do what Parliament should be doing, which is redefining the offences and the maximum penalties. They are limited to existing case law. However, and this is where I want to focus my remarks on what can be done. They need to avoid making this distinction between careless and dangerous driving even more muddled by uprating custodial sentences and making it even harder for jurors or anyone else to see where the role of non-custodial driving bans should come in. So let's move on. So the draft guidance seems to make an even harder assumption that anything involving dangerous will involve, dangerous that involves death or serious injury will result in custody. That is the wrong way to go. We need to make it clearer that it can involve driving bans. And I suspect that this whole thing about the relationship between, the process by which magistrates or the courts, whether it's the magistrates or the Crown Courts, are expected to make this decision, start by deciding, is this a person who needs to be locked up? That really should be the first for public protection. Have they driven in a way that is in the old legal framework reckless? In other words, if they're not locked up, are they likely to go and do it again because they're just going to show contempt for the law? And as I say, contempt for the law can be apparent from the way they've driven, or it could be apparent from the fact that they've got a whole history of driving offences, and particularly if they've breached disqualification. At that point, they probably are someone who needs to be locked up for driving. If not, we really ought to be making greater reliance on driving bans. The same is even more true for the fact that we're moving even further in the direction of custodial sentences for careless driving. Now, there are members of the House of Lords in those debates that Jenny mentioned who are saying really we should be going the other way. If it's something careless, however that is defined, whether it's careless as defined in common parlance or is defined in law, if it's careless, we really shouldn't be locking people up for it. And the idea that we're seeing an uplift for careless offences really does seem to me to be going in the wrong direction. There needs to be scope until we can get the wider offences framework changed. We are still going to see prosecutors and therefore courts convicting for careless offences when they really ought to be convicting for dangerous. And the sentencing framework has to reflect the fact that that's still going to happen, even if we wish it wasn't going to do that. So I have every sympathy with the Sentencing Council keeping some latitude for custodial sentences for those offences that have been classed by prosecutors and the courts as careless, but which really fall into that category of it's nearly dangerous, but actually they probably should be dangerous. But there are a whole load of things that Ollie showed as medium culpability for careless. Frankly, those all ought to be dangerous. And they ought, at least in this context, to be, they are close to dangerous. And therefore, I really would suggest that pretty much everything in the medium culpability category for careless should be moved into the high culpability category. And that doesn't mean it should lead to a custodial sentence, but it should not be dismissed as merely medium seriousness of careless. That really does take us in the wrong direction. So the last point I wanted to make is we've got to be much clearer and much tougher on when a disqualification offence really should almost invariably mean custody. The framework does make some exceptions where there's been where the offender didn't know that they'd been disqualified, genuinely didn't know, or genuinely faced coercion, or it was a genuine emergency. I can understand those being not quite into the level where it results in custodial sentence, but pretty much anything else should. There really is no excuse other than those that I've just mentioned for driving with while disqualified. And if you do, that's when custody really should become a very serious offence. Finally, we need to tackle this exceptional hardship loophole. It's still not working. We're still now, what's really alarming is that the courts now seem to be saying, well, if we're about to trot you up, we'll actually disqualify you instead and give you a short disqualification instead of adding 3 more points to your license, thereby giving a new loophole. And that is really alarming. We've got to find a way to close that new variant of the exceptional hardship loophole, as well as the exceptional hardship loophole itself. And I think that's really, so as I say, there are some things where we've got to be much more open to non-custodial sentencing but driving bans, but when you breach a driving ban, we've got to really come down on it like a ton of bricks. Those are my key messages. Okay, I think that's it, because I've probably run out of time.
Yes, thank you very much, Roger. I'm probably meant to be neutral as chair, but I agree with every word you said. Now, we have 3 more speakers. I'm going to ask Amy if she could decide on whether we have questions now or we leave them to the end. Amy?
I think you're right, Jenny. We should go straight to the other speakers and then just have the questions at the end.
Okay, thank you very much. Next to speak is Chris Miller, and he provides a glimpse into the future, which is obviously very clever of him. He's an ex-Met Police Service officer with a long-standing interest in electronic tagging. He leads on a Road Safety Trust funded pilot project using electronic tags with disqualified drivers in Lincolnshire. Now, this is believed to be the first such project, not only in the country, but in the world. So I will all be very glad to hear how disqualifications can be made more effective and reliable. Chris.
Hello, yes. So the data, about 90,000 people a year get disqualified by courts directly. Another 25,000 get disqualified through totting up, so it's about 120,000 people a year. 10,000 a year get caught driving whilst disqualified. Now, I don't know how many of you have been stopped in your car driving, but I bet none of you have, hardly ever. So these 10,000 people will get caught because they drive the wrong way up a motorway, or they crash, or they have a bad accident. That's why they get caught. Of the 10,000 people a year who get caught, 5,000 have already been caught before, and 800 of them have been caught at least 15 times. And 80% of them have got criminal convictions, and 30% of them have got convictions for burglary and robbery. So not only are they dangerous on the road, they're dangerous people in the community. So the idea of this project up in Lincolnshire is to see if we can manage initially, well, see if we can manage people who will not stop driving whilst disqualified. Now, the big criminogenic theory, which is always cited and in fact makes common sense, is that the certainty of being caught and the speed with which you're caught is far more of a deterrent than any other aspect of deterrent. So the idea of the Lincolnshire project is that because they know they will get caught driving whilst disqualified, they won't drive. But if they do drive, they will be arrested quietly in their beds the following morning, rather than being pursued across country by police with a blue light before they crash into a bus stop doing harm. So that's the idea of the project. The way the tag works, it has an algorithm which associates foot movement right to left with deceleration. Now, those of you that are Olympic sprint fans will know that even though you start after the gun has gone off, you can still be disqualified because your reaction is too quick, and the algorithm picks up the same thing. You can't. The idea is that if you move your foot from right to left and depress the decelerator, your car will decelerate, and a GPS enabled bug in the tag triangulates with the right to left foot movement and the deceleration, and the GPS places you on a road. So the idea of the tag is it will pick right to left foot movement, deceleration, put you on a road, give you the speed, and that then provides a series of data points which says this person is driving and not Ollie, a passenger on a bus, or indeed a passenger in a car, but they're actually driving. That data will then be punted through to Lincolnshire Police, who will then go and arrest these people quietly in their bed the following morning rather than chasing them across countryside. And of course, the idea of the project is to actually cause them to desist from driving, not to actually catch them when they have driven. Now, we have made an assumption that giving them a tag is not likely to make them to drive. In other words, we haven't actually intervened and made it worse. They're not more likely to drive because they've been given a tag. And so in a sense, whatever the result in relation to their driving or not driving, it is a success, because if they don't drive, that's what we want. And if they do drive, then we're going to bring them to account very quickly. So that's the project. We haven't yet. So where we are currently at the moment, that technology always promises much and delivers much slower than you hope, is that we're currently refining the algorithm that sits in the tag. So we have a series of very kind volunteers who are behaving like miscreants. They're wearing these tags. They're not locked on. They've got them tagged on with Velcro, so we do let them take them off when they go to bed. They're currently driving around the Lincolnshire countryside. We're collecting data. They're keeping a log of their journeys. And what we obviously want to do is eliminate all false positives. We don't mind false negatives. But a false positive would destroy the project. And then where we will get to when we've decided that the tags are doing what they're meant to do, namely they are identifying incidents of driving and nothing else, then we will start applying them to the ankles of first-time disqualified drivers. So they will be offered a conditional caution. So if they've never been caught before, they get caught for the first time, they'll be offered a conditional caution. The caution condition being that they wear this tag for 6 months, don't cut it off, and that they undertake an interview with the probation, with somebody at Glasgow University, who's a behavioural scientist. They will have an interview before and after the end of their conditional caution. We can then compare the people that are wearing these tags alongside the disqualified driving offending population as a whole, and the first time disqualified driving offending population across a wide range, to see whether or not it has in fact either caused them to be less likely to drive, or alternatively, if they have driven, we can then assess the speed and safety with which they've been arrested. The long-term aim being, of course, that if this works with first-time offenders under a conditional caution scheme, it can be built into sentencing, so that anybody who gets sentenced for disqualified driving or gets disqualified for a more serious offence, such as the ones we're discussing today, could be caused to wear one of these tags until such time as their sentence is concluded. That's it.
Chris, that's absolutely fascinating. How long is it going to last, the trial with your innocent offenders?
Innocent offenders? They're not innocent offenders.
No, the ones that you're testing the system on.
Oh, I see. The sort of the council workers and the police officers and the ambulance drivers. Well, we want to make sure that they're not generating any false positives. So they have generated false positives. So when the whole thing was tested in a factory with careful factory workers, of course they managed to eliminate all the false positives, but that's a sterile environment. It's now in an unstructured environment where people are they're not misbehaving, but I mean, they're behaving like ordinary people, which is what we want them to do. And they are still generating a few false positives. We have to analyze and research every false positive, and then the algorithm has to be tweaked. Once we are confident that we've had a good run with about 15 or 20 of these tags, because there's something about the size of the data set that's being collected, as well as each individual tag. Once we've got a good run at 15 of them, operating effectively, only capturing drivers driving and not catching pianists playing the piano, basso, as it were, or people playing the drums on a milk float. Once we're happy that it's only captured drivers driving, then we'll move on to the next stage, which is applying to the ankles of offenders. We've made pretty good progress. So it was very slow to start off with, but we've made some pretty good progress over the last 6 weeks, and I think we're going to be ready to pull the let the balloon up, not pull the trigger, let the balloon up, probably around about Christmas time or just after.
That's absolutely fascinating. Thank you so much. We're going to hear now from Joe Morris from Drystone Chambers, because the Criminal Bar Association was invited to participate, and Joe is speaking tonight from the perspective of criminal barristers. So we are very grateful to her for ensuring we hear from that side of things. So, Joe.
Thank you. I'm sorry I'm so late. I had a lengthy journey back from Cambridge Crown Court, which was fun. So I've prepared this on the basis that what you're interested in is the apparent unfairness in some of the draft consultations. And just on a preliminary view of them, it seems to me that there are a number of apparent problems. The obvious point is that some of the things in the draft consultation are rather contradictory. Things like brief but avoidable distraction seems to me to be not dissimilar from momentary lapse of concentration. That sort of thing is quite common with the Sentencing Council. They quite often give us a form of words that is very vague, and case law develops it gradually. But it doesn't really do anything that one wouldn't expect. That was always going to be a mitigating point. But the real issue is that some of the stuff that is currently in medium culpability should really be in high culpability. Under the influence of alcohol, for instance, I can't imagine that anyone would think that that could be anything other than high culpability. I also think disregard of medical advice really seems to me to be higher culpability. If you've been told by your doctor to stop driving and you carry on, there doesn't seem to be very much mitigation in that. But the reality is that even with a higher culpability sentence for this offence, you will still be looking at a starting point that is within the territory for a suspended sentence. And you have to bear in mind with traffic offences that some of them do have previous convictions because they're involved in police chases and stuff like that. But generally, they're the ones that are charged with dangerous driving. With careless driving in particular, it is an offence that can bring the middle classes to court. And you will often have perfectly hard-working, law-abiding people who've just had a meltdown on that day, or done something really stupid behind the wheel of the car and have children. And the judge is always going to consider the impact upon other people of sending a first-time offender to prison. But the current ban is a minimum of 12 months or 2 years if disqualified twice before, for a period of 56 days or more in the past 3 years before the commission of the offence. Seems to me that it would better protect the public if there were a requirement that the offender were ordered to retake his test, which is actually a sentence that we use in many other offences. There are disqualifications until further test is passed that relate to many traffic offences. That shouldn't be an enormous difficulty. But the obvious unfairness, and I think where jurors do struggle, is when and we'll never know because we can't talk to jurors in this country, but I don't think they do think about the consequences of conviction. They're specifically told not to think about the consequences of conviction, and I don't really see any evidence that they do. I think their difficulty is where the driver, the defendant, was not the only person involved in a careless incident, not the only contributor to the accident. And that does quite often happen, particularly with motorcyclists or cyclists. It's less common with horse riding. I must say, I've never seen a horse rider ride carelessly, but there are certainly cases where fault also lies with the victim. And then I think it is very difficult for a jury to feel that the driver has behaved in a way that should be punished by the criminal courts. Or also momentary lapses in concentration caused by something like a collision on the other side of the road, legitimate curiosity, bad weather. Can sometimes have an impact, heavy rain, although generally speaking, you'd expect that to be a positive defence. But protesters, anything of that kind can distract a driver, and that would seem a fairly unfair prosecution. But I remember a case that I was involved in a long time ago. It wasn't careless driving, it was dangerous driving, but the victim had got into the defendant's car willingly, and there was loads of evidence that he'd encouraged the dangerous driving, and it culminated with the car toppling over, driver lost control, car toppled over, and sadly the victim was killed. But I think that was very difficult for the jury because he wasn't really blameless. I don't know how I'm doing on time.
Jill, I wanted to say thank you. You must have had an exhausting day, and to still turn up is fantastic. Perhaps you could leave it there, and then we can perhaps there'll be questions for you if you don't mind. Thank you very much. We're going to move on to Andy Cox, and we're very grateful to Andy because he's in a hospital at the moment and with a family emergency. And so thank you, Andy, and we'll be delighted to hear from you now.
Thank you very much, Jenny, and thank you, Amy, as well for the invite. I've been here all week, which is why I'm wearing my son's hoodie, so I don't normally dress like this, in fairness. And I'm here representing Jo Shiner, Chief Constable for Sussex, and our Rose Police and lead nationally. I know Jo would have liked to have been here, but she's otherwise tucked up, so she sent her apologies as well. I just think I'd start by saying I see the subject heading, and I apologise as well because my notes are all over the place, and I've had Wi-Fi issues most of the day. Describes them as motoring offences, and I think that goes to the heart of some of the issues we're discussing here. For me, they're road crime. I've heard the words a lot tonight about traffic offences or motoring offences, and I think that does go to some of our challenges in terms of understanding the serious nature of what we're dealing with here. Far more people, as we all know, around the table tonight, and I think it's been a fantastic event, by the way, in terms of the presentation so far. But I think many more people will die on our road than through other forms of homicide. And I think we just probably need to reflect and understand that when we start talking about the harm that's caused to communities. And I do think, whilst it's really positive, a lot of the stuff and a lot of stuff that's been included, and I think having death by dangerous, have the ability to sentence to life, is something that we've been calling for a long time. And I think does reflect some of that. But actually and everything tonight we're talking about is when it's too late. And I think we need to probably look at how do we move to the preventative agenda around some of the other offences and how we might tackle them. So extreme speeders, for example. I can think of cases which I oversaw in the Met where somebody drove at 163 miles an hour and their sentence wasn't particularly strong. And I think when you consider, some of the other harms in our communities, knife crime, domestic abuse, child abuse, really, rightly so, really strong sentencing. But having met loads of bereaved families and crash victims, you try and say to them that this is anything less, and it doesn't deserve as much and so on. So I think we just need to reflect on that preventative agenda, reflect on the language that we use. Now, I personally feel, and I also think in terms of when we start to look at vulnerable road users and how we might protect them as well, delivering justice to victims. I think there's a lot of work we can do to further enhance the product here. But I do think so. Death by dangerous, we're really pleased. We also think around the harm and capability. We'd just probably like to reflect on some of the disqualified driving aspects of that, because it is choice ultimately to be just to go out when you're disqualified, and it kind of has a blatant disregard for the CJ system at large, court outcomes, the public. It's disregarding the fact they've been disqualified and they've gone out and done that. And I think a lot of the actions as well, we talk about dangerous or careless. Those are choices, aren't they, that people are making behind the wheel. It is a choice to drive dangerously. It is a choice to be. I use the word reckless, but see, legislation uses the word careless. It's a choice to be careless, and I think we just need to understand that as well and consider that. But I do think more broadly, it's a much more, it's very difficult for the magistrates, it's very difficult for the criminal courts, and everybody involved when the wider society doesn't really understand the impact here. So I think there's a bit about marketing, and that's how you might influence jurors. That's how you might then influence wider understanding. And if I could just pick up, and those that follow my Twitter account would be amazed if I didn't mention it, exceptional hardship. I find it staggering that we continue to allow that defence. Well, not defence, that's ultimately mitigation, sorry. And I think the exceptional hardship is with crash victims and other road users who are exposed to somebody that's secured so many points they should be disqualified and then continue to drive. And there are cases, of course, which go on to with somebody who's pleaded successfully and secured exceptional hardship that's then got involved in a crash which kills somebody. And I think, as I say, the hardship is with families and other road users who've lost loved ones and so on through a crash and through dangerous driving. And I just sort of, I suppose, say, and I know the point that was made, I think, earlier on is that we recognise they've totted up enough points. We recognise they've therefore been sufficiently dangerous and haven't learnt their lesson to continue to top up the points. And I think what was being put forward is that the impact to employees they might employ as an employer. I just go back and I understand that impact, and I do honestly genuinely see the impact to other people if this person were to lose their business, for example. But even that doesn't compare to the danger that's put it on the road and for victims who've lost family members and so on. I think ultimately this is about recognising the seriousness of road crime, the seriousness of dangerous and reckless drivers, and making our roads safer for everybody. And I think the impact is much more with them than anybody else. And then really just to say, I'd like much more focus, as I say, on victims and the impact to them. So there's a lot we really like. It's a really big step forward in many regards. But I think there is some wider understanding and just some sort of real putting victims at the centre of what we're talking about, really. I'm sorry, I can't be more thorough. I haven't got a presentation prepared and it can't be more thorough than that, but obviously the circumstances aren't ideal. Thank you very much, Jenny.
Andy, thank you so much. I didn't even introduce you because I assumed everybody would know who you were, but you are a Detective Chief Superintendent up in Lincolnshire, and you do represent the National Police Chiefs Council, leading on road death investigation. So thank you so much. Now we've only got about 4 or 5 minutes for questions. Amy, is there a good question somewhere in the audience?
We haven't had any come in through the chat, yes. We can just ask, but I mean, I think if the speakers wouldn't mind staying on for a few minutes, we would really appreciate that.
That is very kind.
I'd like to,
yeah.
Can I just pose a quick question to Ollie? If you could, you mentioned about, I think it was Ollie or Sally, who was talking about aggravating factors or separate offenses being sentenced concurrently versus consecutively. Are you, okay, Sally, I mean, I just wondered if we could mention that a bit, how it's decided whether another offense is treated sentenced consecutively or concurrently.
So if it arises out of the same behaviour, the same incident, well, this isn't a motoring offences issue, it's how it's applied across the board. It will be sentenced concurrently. Consecutive offences are for different instances of wrongdoing. Okay,
my example was with failing to stop, because that's being proposed as an aggravating factor, but we would argue that it is a separate act in causing the collision. So that's good.
No, it would be. My understanding is, and there are other lawyers on the call who can correct me if I'm wrong, that would be concurrent.
Okay,
I mean, that must be concurrent. That's the same chain of events. Consecutive sentences arise, I don't know, in circumstances where you do an offence on one day and then 3 days later another, rather than offend in one course of events.
Ollie, did you want to come in on this at all? Having heard views.
Yeah, I agree that would probably be the case. I think there might be scope for it to be done a bit differently if it was to do with disqualification. But I'm trying to think of the scenario. If you've caused death by disqualification, then that's one thing. But if it was dangerous driving, then obviously you'll be done for dangerous driving, causing death by dangerous driving, and then the disqualification could be added onto the top. But in that case, the disqualification is going to be so minimal that it will just be silly. So it'd probably be concurrent anyway. It's not. It's one of those areas that there is a little bit of dark arts about it sometimes. I shouldn't say that, should I? It's all clear.
Well, Ollie, you didn't sound very keen on the driving bans because you felt people would think, you know, what's the point? I might as well, you know, hung for a sheep as a lamb or whatever. But having heard some of the views here, do you see that slightly differently?
I do see the strength of feeling about disqualification and a greater use of it. I think it is different to the question of the sort of primary sentence that we set out in those tables, because those are focused very clearly on the seriousness of the offence, at least at the first stage when you're setting on a starting point. And whereas a disqualification is going to be based on a whole other range of factors, including the psychology of the offender. So I suppose it's true that you could develop something like a whole separate guideline within a guideline in terms of the offender's psychology. You can get pre-sentence reports that looks at where they're going to be a risk in the future. It feels like, but as I say, we probably end up putting quite large ranges down to account for a whole host of possible outcomes that would be meaningless. And as I say, if you're, you know, I can't criticize, of course, the new minimums, the 5-year and repeat 6-year minimums for causing death by dangerous and causing death by careless under the influence, but those are vast disqualification periods. Someone could spend 8 years in prison, quite feasibly, be out, well, these days be out after 5 or 6. You've got to impose 5 years on top of that into the future. Maybe many of you would agree with that, but that's a very lengthy time for someone to be off the road when you want them to be rehabilitated, to be getting jobs, possibly involving driving, or to at least to be active members of their family and driving the kids to school, etc. I know that's probably a stereotype that doesn't apply to many of them, but
as a politician, I actually want to see fewer custodial sentences, because if we were serious about it, we would need a lot more prisons, and we do not want to send people to prison for things like this. But that does mean that the other sentences have to have power and be serious.
Yeah.
Would any of our other speakers like to come in on this? Chris, you've unmuted, so I'm guessing you want to say something.
Yeah, I'd say disqualification is a really interesting thing, isn't it? Because it's a summary only offence, so the law doesn't treat it terribly seriously. And in the police, it's not even a notifiable offence, so the police don't have to report it to the Home Office in terms of the number of events. Now, a prison governor on release can stop you having a relationship, getting a job, or living in a particular place. You could transfer some of the responsibility of this to prison governors and say that the prison governor on release could say, well, you can't drive a car for 12 months because actually I think until such time as you've demonstrated, or indeed you could give it to the probation service, because the probation service could stop you having a relationship, taking a job, or living in a house, all of which are bigger things than driving a car. And we quite happily hand that responsibility over to offender managers. So, I mean, you could have a complete rethink about either it's really serious or it's not. And at the moment, the law doesn't, it's a summary only matter. The police don't have to report it as a notifiable offence. That the Stat 19 documentation doesn't. So if you want to know how many people get killed as a result of disqualified driving, you can't find out because it's not recorded as a separate event on the Stat 19. Unlike taking too much paracetamol, which is. So I mean, it's. I'm sorry, I'm just wittering on really. But there would be other ways of looking at it rather than just sort of seeing it as a court-derived event that needs to be policed through that way. Anyway, there's a thought for you.
Well, I'm hoping Molly's going to take away all these thoughts and perhaps.
Yes, I'm taking away all of this.
That's fantastic. Amy,
you see, got a question from David Davies. Be interesting to hear.
Thank you. Well, if you permit me, it's not really a question. So it's been fascinating, and I'm no expert in all this, but it does seem to be there's actually quite a consensus, and it seems to me there's a couple of things. One is causing death by dangerous driving. That has been settled, and there's been a big outburst from victims' families who want justice, what they see as justice. But I think what we're talking about now is how to prevent. Most of the people around on this call are about preventing further offences for the death, you know, or injury. And I think, you know, we want stuff that's effective in that regard. And frankly, that's often not custodial sentences. So I think I'm really impressed how much attention there is for making bans effective, but maybe supported by electronic tags and possibly other technical devices. You know, I mean, a lot of countries now are looking at alcohol interlocks to prevent reoffending in drink drive cases. So, you know, so Ollie, I hope you know you can turn that into something something useful, because I think that's what it's really about. It's about preventing death rather than retribution in this case.
Thank you very much, David.
Can I just jump in there too, real quickly, because we highlighted this in a blog we did about the consultation, because like for the past 7 years, or not decade, our Department for Transport has adopted what's called the safe systems approach. And that accepts that people, especially drivers, will make mistakes, and that the onus ought to be on the transport operators, the policymakers, the politicians, to design out risks so that when they make those mistakes, they won't be fatal or serious injury. So they won't be able to stop people who willfully or go out of their way to break laws, but the ones who make inadvertent errors. That's what's supposed to be being designed out of our system. And those are the ones that would say you should not be considering custodial sentence for those careless drivers, even if death and serious injury results. Yeah. Thank you.
I've got one more thing to say, and it's a pet hate of mine, and that is that the word accident has been used a couple of times, and even the Met talk about collisions or incidents. They don't talk about accidents, because that sort of suggests, oh, whoops, I didn't mean to do that. It's a prejudgment of what happened, but that's my tiny little pet hate. So, Amy, are we going to wrap up now? Are you? Can you see any other questions?
We had one question, which I think was for Andy Moore. It was just talking about, let me go back and get that one. Yeah, we had a question about the video upload, the police portal. How vital has that been in securing convictions? That would be really interesting for us to know. Does it help with early guilty pleas?
Well, it's really, really important, to be fair, mainly for deterrence, I have to say, because I think, you know, the police can't be everywhere all the time, but the public can. And I think drivers tend to look for speed cameras, they look for police cars, but if they want to be dangerous or reckless, they're more inclined to be so if they don't see either of them. But now they know essentially everybody can report them, then I think that will have a deterrent impact. From an investigative point of view, we're seeing referrals rocket. So, you know, they just continue to increase as more people become aware. There is national guidance out there now that encourages every force to make it available. And I am trying at the moment get all the data together from each force to look at how is it being used, what's the enforcement ratios. But everything indicates about a 2/3 enforcement. So 2/3 of every referral will be enforced in some regard. That might be warning letters, but it goes all the way through to court cases. And I have seen drivers lose their license on just a submission alone. So it does have anything from no further action about 1 in 3 to warning letters, and I don't quite have the data, there's a fair few of them, but then it moves through the categories, and say it does end up in people losing their license. And I think one got a suspended prison sentence recently from a referral I saw as well. So it can have really significant judicial outcomes, and we obviously, you know, really encourage it and want people to use it. And, you know, we are continuing to improve, so we're not we're not as good as we'd like to be everywhere in the country, but, you know, ultimately standards are improving in my view, and we will get there. It's just work in progress, but it is available now across the country.
And can we just squeeze in one last question for Ollie, because I think it's let me see, it is James Muller who's got a question for Ollie about the bottom end of death by careless driving, and I'd like to hear that because I think that is a real contentious area.
Hi, Ollie. A lot of the cases I deal with are individuals who make very sort of short, momentary mistakes, pulling out of junctions when there is something coming. It's a classic one. The other one is turning right, and usually missing motorbike or cyclist. It was quite interesting because there was some comments from different speakers today that they thought that the bottom end and the sentences at the bottom end may have been lifted up too much, and maybe shouldn't be at that bottom end shouldn't be those who are at risk of custody. And a note under the old guidelines, of course, we had where the level of carelessness is low and there are no aggravating factors, even the fact that death was caused is not sufficient to justify a prison sentence. And obviously we've moved from that to starting point of 26 weeks. And it's really, firstly, why has that approach been taken? And secondly, I guess it is transposing all the sentences up rather than stretching them out the right approach. I think we all recognise the top end needs to have, you know, the significant enough sentencing powers, but has the bottom been brought up too much, really, is my question.
Well, I think as a broad point, I'd say that, you know, what we're trying to reflect in these many custodial starting points is the fact that we've got to recognise that when you get behind the wheel of a car, you're doing something which is inherently dangerous and that you can cause real harm with it. I mean, as another very broad point, obviously the really difficult thing with driving cases, with motoring cases, is you've got some very high harm outcomes from some very low culpability behaviour, some of which you've just outlined. But you do have that harm, and sentencing is about harm as well as culpability. Well, it is. The law is that it is, and unless there is a radical shift away from that, you've got to accept that life has been taken, and that has to be reflected. Now, whether we've gone up too far, well, I mean, I'm open to what people are saying here and what people will inevitably have said in response to consultation. Another factor that we haven't thought about, first of all, we were talking about the fact that we've got to include a bit of proportionality. We don't have to go to town, but a bit of proportionality with the death by careless, sorry, the death by dangerous levels, which have gone up because Parliament wanted them to go up. So it's unrealistic to expect they won't slightly go up in step. The other issue is that we've got a new offence of causing serious injury by careless, and people will have life-changing injuries from careless driving that will leave them in vegetative states or whatever for the rest of their life, needing lifelong care. Now, those need reflecting with substantial sentences, maybe suspended ones, but those the harm caused by that needs to be reflected as well. And so, you know, reflecting the difference between a death being caused and some very serious harm, we've got to build those in. So I think, you know, there is sort of pressure from above and pressure from below when it comes to causing death by careless driving, and it's got to be reflected somehow. You know, the harm, although it is perhaps less than in other offences, in other guidelines, does still have to be reflected there.
Ollie, thank you so much. I think it's appropriate to finish with Ollie's statement. I want to say this has been an amazing session, and Action Vision Zero really needs to be applauded for it. And thank you so much to Amy, who's put in so much work for this. It's been incredibly valuable. So.
Thank you, Jenny. Thank you. Good night.
Good night to everybody. Thank you so much for coming. Thank you.
Thank you all.